welcome. And how about you introduce yourself to our audience and let them know about the role you're playing in this hearing?
Yes, hello. My name is Ben Gutman. I am the Solicitor General of Oregon. It's a job I've held for about 10 years. That means that I am the head of the appellate work at the Oregon Department of Justice, which represents the state of Oregon in courts. And my role in this case is as a lawyer for the state of Oregon. We have 12 states that have sued the federal government over the imposition of these tariffs. Oregon is one of the lead states organizing that coalition. And um, and so I am the attorney who will be representing that coalition of states in the oral arguments in the U.S. Supreme Court in November.
Okay, thank you. Welcome. So, first, I want to just begin by, looking ahead. What should Canadian policymakers, business leaders, investors be looking for when it comes to the impact on Canada, particularly from an eventual ruling in this case?
Well, the impact could be enormous, regardless of which way it comes out. Under the United States Constitution, the power to impose tariffs or to raise tariffs is a power that's committed to Congress, to our legislative body. Um, what the president is claiming in this case is that Congress has delegated that authority to him to impose tariffs, to raise tariffs of essentially any amount on any products, on any countries at any time, for any length of time. And so if the courts ultimately determine that the president has that power, that is an enormous control of one person over not just U.S. trade policy, but the international trade system writ large. And so that, I mean, Canada is obviously a very important trade partner with the United States. And so the question of whether there are tariffs and how much tariffs is an enormously consequential question. Um, and again, the president is essentially claiming the unchecked power to be able to make that decision on his own without any input from our legislature.
Okay, thank you. So one of the unique circumstances when it comes to the application of the IEEPA tariffs in Canada and Mexico as well is that the administration granted a pretty wide-reaching exemption for any goods that are compliant with the United States-Mexico-Canada agreement. And that could have an impact sort of in two ways. One, it's really shielded the Canadian economy from the full force of the tariffs, separately, of course, from the sector-specific tariffs that we're seeing applied under Section 232. So I want to kind of talk about the sort of two major potential scenario outcomes here, and maybe start with if you lose the case. So I think there's a feeling that the IEEPA tariffs at this point are not top of mind for Canada. I don't want to say they're nothing, but they're not top of mind. And yet that exemption was also just part of an executive order, and therefore there is an awareness that that could be revoked at any time as well. So in the event that the IEEPA tariffs are allowed to stand, and Canada still gets that exemption, though, what should Canada be looking for or be concerned about that outcome?
Well, the concern is exactly what you've already alluded to, which is that exemption, like the tariffs themselves, exist at kind of the unchecked discretion of whoever happens to be sitting in the White House. Um, and and this is not just about what President Trump might do with that power, but what future presidents might do if they have that authority, what exemptions they might or grant or not grant, what rates they might impose or not impose. You certainly have seen, for example, with what the president has done with tariffs on China, that they've gone from 10% all the way up to, I think, 145% and back down to 30% in a matter of days. That's no way to have a stable trading relationship. And so if the president has that sort of power, that's a power that can be abused. And if it is not being abused at present because the president has exempted so much from, specifically with respect to Canada, that's great, but that's not much of a guarantee. What we're looking for is a court ruling that would restrain the president's ability to do this unilaterally.
Okay. So now moving on to the other outcome, the one that you are obviously hoping for. Um, Given there is an exemption and given Canada is hit hard by several layers of Section 232 sector-specific tariffs on pretty major industries for us, including our auto industry. There's a partial exemption from the Trade Act there. Steel, aluminum, growing list of derivatives for both, copper, lumber, which is no stranger to Canada-U.S. sore spots, and yet much higher than it ever used to be. So in the outcome, the IEEPA tariffs are lifted, are struck down. What can Canada anticipate about those tariffs, which aren't subject to this case, or whatever the administration might want to do next?
Yes, well, if we prevail in this case, that will mean that the president cannot use IEEPA to impose tariffs, and that should give some greater degree of certainty about what can and can't be done with respect to tariffs. As you say, this case does not touch the Section 232 tariffs. It doesn't address the president's power under various other statutes that exist that do expressly allow the president to impose tariffs in certain circumstances. Each of those tariffs, each of those statutes, including Section 232, have specific procedures, have specific limitations. Um, and so they are powerful tools that a president can use to impose tariffs and maybe the subject of other litigation. Um, but but they are not the kind of any amount on any country at any time for any reason with no warning that we're seeing with IEEPA. So I guess my hope is that if we prevail in this case, we will bring back a little bit more of a sense of stability, even though the president still has many other tools that he can use with trade. The other thing is, of course, if we prevail in this case, it will be up to Congress to decide whether to give the president additional authority or to impose additional tariffs. That's the way our democracy works. So if they choose to do that, then the president would have additional tools. But the main thing that I think we would see from a win here is taking away this unchecked authority.
This is not a sort of routine moment in history, right? And so what opportunities are you looking for in the role of the judicial branch, and what concerns do you have about it as well?
Well, what we're looking for is for the judiciary to enforce the law. That is their job. That is what they do. And that means interpreting the law and clarifying the law and enforcing the law. And there's no doubt that that becomes all the more important in a situation where you have an executive branch that is asserting new and unprecedented authorities and doing things that have not historically been done. That does raise new legal issues that the courts have to resolve. But I'm very confident that they are up to resolving those issues. I mean, this case is fundamentally about the interpretation of a few words in a statute that Congress enacted in 1977. Um, we will get an answer to that one way or the other, and then we will all know what the rules of the game are. Um, but there's no doubt that the courts have a very important role to play at this historical moment, as they have at other moments when presidents have engaged in actions that could have been viewed as overreaching. So we're looking forward to presenting our case. Every court that has addressed this issue so far has agreed with us, has addressed the issue on the merits. And so we have a lot of confidence in the judicial system.
Okay, thank you.